the latest ARBV webinar in its CPD webinar series. The title of this presentation is Guidance Documents and Tools for Producing a Compliant Design. My name is Frances Hall. I'm a Special Counsel with Weir Legal and Consulting. We are a legal and consulting firm, and we provide advice and legal support to regulators and to government departments throughout Australia, and with a particular focus on building regulation and also architectural matters. I will be joined today by Germán Ferrando Miguel from the Office of the State Building Surveyor at the Victorian Building Authority. Germán is the Manager of Regulatory Services in the Office of the Building Surveyor at the Victorian Building Authority. He is the manager of the team that interacts with policy makers in designing and developing changes to legislation, regulations, and technical standards. The development of binding determinations sits within his team. Germán brings 16 years of experience designing and implementing regulatory reform in the public service in the areas of environment protection, energy efficiency, and more recently, building and plumbing. His favourite architect is Antoni Gaudí, and his favourite building is the Hundertwasser house in Vienna. And apologies if I mispronounced that, I'm sure I did. So we will start with an acknowledgement of country. We respectfully acknowledge the traditional owners of the lands on which this seminar is being presented and wherever attendees are situated, in particular the Wurundjeri people of the Kulin Nation, and we pay our respects to their elders past and present. Now, our process for today is I'm going to start with an overview of what the webinar content is going to be. There will be some quiz questions that are interspersed in the presentation today for your CPD purposes, your learning purposes, and we hope to also have some time left over at the end for questions. If you do have questions, please put them in the Q&A function in your Teams. And please try and keep the questions reasonably general, as we can't answer. We obviously can't give advice on specific topics. So the webinar today is I suppose addressing the various resources that are available to you in relation to ensuring that you have design compliance. Obviously, producing compliant designs is of critical importance for designers and architects, but also it's also relevant to understand any issues that might come up during the building work process, to the extent that any of you are involved in contract administration or other services, either before the building permit is issued. It's very helpful to understand what resources are available when issues need to be assessed and determined. So in the first instance, you'd all be aware that design and siting requirements are governed primarily by the Building Act, the Victorian Building Act, and by the building regulations that accompany that Act and the National Construction Code. I'm sure you will all have encountered the reality that those provisions can be complicated, and they can be difficult to interpret and difficult to apply in specific factual scenarios. Of course, the first recourse in determining what a design requirement is to look at the legislation. So the Act, the regulations, or the particular provisions of the National Construction Code. But there are also other documents that are available to assist you when that's not clear, or when there might perhaps be a dispute about how a particular provision should apply. And that's what we're going to talk about today. So I will be talking about ministerial guidelines issued under the Building Act, about practice notes issued by the VBA, and about NCC guidance materials. And just a quick note for my comments, to the extent that I'm commenting on VBA material, I should say that those are the comments of me and of We're Legal and Consulting. They're not VBA commentary. And we're then going to talk about the recent amendment to the Building Act to allow binding determinations. And that is what Herman is going to talk to you about today. What are binding determinations, who issues them, and what's their effect? And for all of those different types of resources, what's the legal effect of those documents, and how should they be used? So next slide, please. Thank you. So ministerial guidelines. So ministerial guidelines are documents that have been issued by the minister who has authority in relation to Building Act matters. And I should say there are all sorts of ministerial guidelines under various pieces of legislation, but for our purposes today, I'm just going to talk about the Building Act ones, because they are the ones that will have relevance to you in the design, in the preparation of building designs. So they are issued pursuant to specific powers given to the minister under the Building Act, and ministerial guidelines have the force of law, so they must be complied with, and to the extent that they contain interpretation in the guideline, that is binding. So there are 15 ministerial guidelines that are currently in force under the Building Act. Not all of them will be relevant to architects, but taking into account the ones that are most likely to be relevant, we'll look first at Ministerial Guideline 12, which is the guideline issued in relation to the siting and design of single dwellings, noting that that's recently been updated to respond to planning changes relating to small secondary dwellings, previously called granny flats. So Ministerial Guideline 12 operates sort of interacting with Part 5 of the building regulations. So Part 5 of the building regulations sets out a raft of generic siting and design requirements for Class 1A buildings on a site, but Part 5 only applies where there isn't a planning permit required for that building work. Where a planning permit is required, then it will be the planning scheme for that municipality that will govern those siting and design requirements. So if you're in a position where there is no planning permit required, and so Part 5 applies, and where report and consent is sought for a variation to Part 5 requirements, and I'm conscious that it's very common to seek report and consent, Ministerial Guideline 12 must be followed by the reporting authority. So it's very useful for architects and building designers to know how the guideline operates, so that they can gauge whether a variation is likely to be approved and what the sort of things council will look at when deciding on a report and consent application. So I've set out here just a page of what the guideline looks like. So you can see it starts out with a paragraph that sets out the purpose of it. It then goes into definitions, I haven't set out the entirety of the guideline because it's quite a number of pages, but then it will go section by section through each of the citing requirements. So if we could go to the next page, please. So the guideline sets out 17 different citing requirements, and you'd all be familiar with these sorts of requirements. They have to do with the setbacks from the front, the side and the rear, building height, site coverage, private open space, overshadowing. For each of those 17 requirements, the guidelines set out criteria that the reporting authority must consider. And those things vary depending on what the requirement is, but they include things like amenity of existing neighbourhood dwellings. They include things like disruption to the streetscape and other things like that. So we could jump to the next slide, please. So that just gives you an overview of how that guideline works. And if you read through it, it should leave you with a good sense of the approach that council should be taking when considering a report and consent application. So it's a really useful document to have. So I've listed here some other potentially relevant ministerial guidelines. That includes Ministerial Guideline 3, and that governs how a council should decide a request for reduced setback in terms of the views of neighbours, of neighbouring owners. MG 11, which is building permit and planning permit consistency. I'm sure you'd all be familiar with the requirement that the design that accompanies a building permit application must be consistent with the approved planning permit drawings. But the question is, how do you assess that, and how does a building surveyor decide what matters are relevant in determining consistency? So that can be a useful one in terms of understanding how a building surveyor will approach the assessment of the documents that are supplied to them when they're assessing a design for a building permit application. Then there is Ministerial Guideline 13, which relates to the exercise of discretion when applying a new building regulation or an amendment to a building regulation. So again, you may be familiar with this process, but Section 10 of the Building Act says that the version of the National Construction Code that is in force at the time that they are assessing the building permit application, or at the time that the design has been substantially progressed, is the version that will apply to that building work. That can be very important. I'm sure you'd all be very aware that it can take quite some time for a design to progress from the initial sort of pre-planning permit phase to the building permit phase, and it is sometimes the case that the National Construction Code will change in the meantime. And so the question of which version will apply to the building work can be quite a fraught one. And this ministerial guideline sort of governs how building surveyors should be making that decision. And the last one is Ministerial Guideline 15. This is one of the more recent ones. It relates to remediation work proposals for mitigating cladding risks for buildings containing combustible cladding. So next slide, please. So if you need to have a look at any ministerial guidelines, they are all located on the VBA website. This is their current location. And I would recommend, with all of these resources, I would recommend that if you download one and save it to your desktop so that you can continue to refer to it. It's always a good practice to make sure that the version that you're looking at is up to date. Ministerial guidelines can change over time, or they can be revoked or replaced with new ministerial guidelines. So it's good practice to make sure that you're relying on the correct guideline. So I'll now move on to VBA Practice Notes. So practice notes are documents issued by the VBA which provide guidance on interpretation of requirements under the Building Act, including design requirements. There are two categories of practice note. There are building practice notes and plumbing practice notes. And you'll see if you have a look on the VBA website that they are sort of categorized by issue type. And each sort of issue type, there might be, 3 or 4 different practice notes that relate to that particular type of issue. They differ in length. Some can be, the building ones can be more of a more general sort of overview of the particular issue. The plumbing practice notes tend to be very technical and very detailed. Thank you. What are they used for? They're designed for use by building practitioners, including building designers and architects. So each practice note, you'll see when you look at them, specifies the intended audience for them, which frequently includes architects. So they're intended to provide practical guidance in how to apply the requirements that are set out in the Act and the regulations and the NCC. They might give examples of how the provisions should be applied. They might include diagrams to assist you in understanding how the provisions work in certain scenarios. It is important to note they don't have the force of law. So they provide really useful practical guidance, but they are not a legislative tool or instrument themselves. They're not incorporated into the Act or anything like that. They've been developed by the VBA to assist practitioners in understanding how the Act works. So, thank you. So they are used by building surveyors when reviewing design documents for a building permit application or when issues arise during construction. They can also be used by councils. You'll all be aware that councils have enforcement powers under the Building Act. And they also have sort of pre-building work functions, so things like report and consent applications. So they might have recourse to those practice notes when considering how a particular issue should be resolved. And they may also be referred to by parties in Building Appeals Board proceedings or other court proceedings where there is a dispute about how the law applies to a particular building issue. They might be regarded as being of assistance to the court in determining that issue, but they're not binding on the court in making a decision. Next slide, please. This is an example of a plumbing practice note. And again, I haven't included the whole document here, but it's just an example so you can see how it's been set out. You can see up the top, it has the intended audience, which includes architects and building designers. It sets out the purpose of the practice note. It contains the common definitions, and it then moves on to the sort of operative provisions. Next slide. So you can see here, for example, it includes different types. This particular practice note relates to box gutters. It's giving sort of some diagrams so that you can see how the provisions might operate. Next slide. And it includes helpfully some photos which give examples of non-deemed to satisfy box gutter installations. So it's quite a detailed practice note, and it's designed to enable designs to be as complete as possible. Is one of the purposes of this sort of a practice note. Next slide, please. Okay, so practice notes can be found on the VBA website, and I understand also that the AIA is also publishing new practice notes as they get released through their fortnightly newsletter. So if you are subscribed to that newsletter, then you should be informed of new practice notes as they get released. Again, as with the ministerial guidelines, I would say you should always check whether you're using the most up-to-date version. The VBA goes through a process of periodically reviewing and amending those practice notes, so it's good practice to check whether it's the most current version. Next slide, please. Okay, so we've come to our first quiz question. And the question is, what is the legal status of VBA practice notes? I should say there should be a poll come up. If you can't see the poll on your screen, then you can put your, please put it into the question and answer function on your Teams. So the question is, what is the legal status of VBA practice notes? A, are they incorporated by reference into the Building Act? B, do they provide authoritative guidance but aren't binding? C, they are binding on registered building practitioners. So I'll give you a minute to put your answer. Okay, so I can see the answers here, and most of you got it right. The answer is B, they provide authoritative guidance, but they aren't binding. So I'm now going to pass over to Herman, who is going to talk to you about binding determinations. Thanks, Herman.
Thank you, Frances. Thank you, everyone. I can see a hand up. Is that something that we address with, or? I'll keep going with my presentation, and then I'll let Carly manage on the back end. So in terms of the binding determinations, what are they and why were they made? The important thing to understand about binding determinations is that they are not just a tool, but they are a legislative function of the State Building Surveyor under the Building Act, with the changes that came through in February 2024. So what that means is that in contrast to a practice note, which may give, and they are a tool that can be used, this is actually a function that is given to the State Building Surveyor within the PBA, obviously. they are an interpretation of a standard or a requirement. So they are a standard setting tool. They are not a compliance management tool. They are not to establish compliance, or they are not to manage compliance, but they are enforceable. They are not guidance. They are not advice. They become and they achieve the same status as the regulations or the legislation or the legislative instrument that they are interpreting. So they can cover both building work or plumbing work, but they need to operate within the existing framework. They might not be inconsistent with the Act or the regulations that they're interpreting and the broader legislative framework. So they can be used to provide a binding interpretation of what's required, but they also need to be mindful that they cannot create a new obligation if that obligation doesn't exist in the existing framework. They cannot modify an existing regulation or an existing standard. They need to provide a valid interpretation within that regulation or standard. They are not to impose new standards or new administrative requirements. They can interpret what level of administration or evidence may be required, but they cannot create a new administrative requirement. And that interpretation must be anchored and consistent within the existing framework. So, for example, the one critical aspect of the building and plumbing framework is the availability of the practitioner to choose deemed to satisfy provisions versus performance solutions. And the NCC covers the different elements of performance solutions and the methods that can be achieved. So a binding determination, for example, could not change the availability or not of deemed to satisfy or performance solutions in that regard. However, it might interpret what might be required in each case. The binding determinations, they need to be published on BBS website, and they need to be gazetted for the duration that the binding determination is valid. What that means is that we can choose when the state building surveyor chooses to issue a binding determination. It can determine the date of the publication as a date that it becomes valid and it starts, or it can gazette with a later date for implementation. And that is a valid tool and a good way to actually manage some transitional arrangements and make sure that the industry understands the obligations that are interpreted in that binding determination. Because of the nature of this tool and this function, which is equivalent to basically making regulations in a way, but interpreting within the regulations, the maximum duration of a binding determination is 10 years, but they can be revoked early if required. Why would we need that tool or that function? Well, as I said, they are an enforceable tool and they prescribe an interpretation of technical standards and requirements. And so they are a very valid tool and very powerful tool to focus on instances strategically where divergent interpretation is prominent in the industry, and we can see, or we have intelligence that some of the interpretations are leading to harm and not meeting performance requirements or standards. So in that regard, it's a very valid tool, very powerful and very robust tool to set clarity and give clarity as to what can be interpreted or not. The next one, please. So where do they sit and when will we issue binding determinations? They sit within the broader objective and functions of the state building surveyor. And those are to drive improved building system performance and policy outcomes. So what the building surveyor has a number of functions and objectives under the legislation. They need to drive improvements of standards and the regulatory frameworks, and the state building surveyor also needs to support practitioners with advice, guidance, and education. So it's a complementary tool, the binding determination, that sits within that framework of driving improvements and driving clarity. These empower the VBA to implement then the compliance and enforcement policy framework. So the greater clarity and the greater the level of knowledge out in the industry of what is required and how to comply, then the more visible the VBA can take compliance actions, basically. We will use this tool strategically on areas of existing concern and alignment with the VBA's regulatory policy statement, which is published on our website, and you can access it. You can see what it means, and you can see how it relates to architects and designers in general. The binding determinations will be used proactively. There is no provision under the legislation that allows for applications from industry or from interested parties to suggest or request a binding determination being issued. However, we are obviously, as part of our normal duty and engagement process, consulting with relevant industry, big bodies and professional associations to get their feedback as to where they see that and what are the areas where this tool might be best deployed. Because they are unenforceable and they are an interpretation of regulations, standards, or legislation, they are not appealable to VCAT, but they are appealable to the Supreme Court of Victoria, and that is on a matter of law. They are not on the technical basis of that interpretation, but they are on the legal basis for that interpretation. Can I have the next one, please? So how are we going to go about, how are we going about actually issuing binding determinations? We have developed a policy and we are finalizing our protocol. Though that protocol and that policy obviously needs to be integrated within the broader set of tools, as I indicated, that the state building surveyor has at its disposal to solve a particular issue of clarity. So within that framework, the state building surveyor can choose to issue a binding determination or follow a different pathway, like publishing a new practice note or engaging with the department and the Ministerial for the need of a ministerial guideline, for example. So there are different avenues that the state building surveyor can progress. Similarly, if the issue is about a particular technical requirement in the regulations or in the NCC, through my team, the state building surveyor has the opportunity to engage with either the Australian Building Codes Board or the relevant policymaker owning the legislation and the regulations to manage the process of regulatory change. So those are all different avenues and different pathways that are available for the state building surveyor to create or improve, where possible, the clarity of what is required. If those are not optimal avenues or tools compared to a binding determination, then the state building surveyor has the ability to issue a binding determination, enforcing or prescribing a particular interpretation. That doesn't mean that we need to choose one or the other avenue. The state building surveyor can choose two different avenues or the use of two different tools to solve a specific problem. So they can issue a binding determination on a particular aspect, but at the same time initiate the process and engagement with policymakers as to the value for regulatory changes to improve that level of clarity on a more permanent basis. We can also do that in terms of education. We can choose to issue a binding determination, but at the same time enhance or strengthen some of the practice notes that are already there or create new ones. So those are the different tools or the different ways that the state building surveyor can give effect and use its function of issuing a binding determination. Can I have the next one, please? So the question is, what does the state building surveyor need to do once a binding determination is issued? So do they just need to send an email to industry? Do they just need to publish a note on our website, on VBA's website? Do they need to publish it in the Victorian Gazette? Or do they need to publish the binding determination in VBA's website and in the Victorian Gazette? I'll give a minute. And similarly to Francis, if you can't see that, feel free to actually post your answer in the Q&A section. Okay, so the number of responses is now steady at around 368, 370. And yes, the vast majority of you are right. The state building surveyor needs to publish the actual binding determination in VBA's website, so not just a note about it, and needs to gazetted in the Victorian Gazette. That doesn't mean that as best practice, the state building surveyor will do those two in terms of legislative obligation, but it will also engage with industry and broaden the communication of that binding determination via publication of notes and sending emails to industry. So in technical bulletins, for example, issued by the VBA, or in other electronic messaging. So we will boost those two avenues to make sure that we reach industry and they understand that a binding determination has been issued and what are the implications for them. So in that regard, I thought that given the high-level concept of what a binding determination is, and that it has a very particular niche element of being constrained but very powerful in terms of interpreting and not changing, but interpreting what the standard is or what the regulations say, I thought that I would choose an example. It's a hypothetical example. It is not in any way, shape, or form, or cannot be construed that we are actually looking into this as an actual target for a binding determination. In fact, we're not. But for example, the new livable housing provisions they have in the NCC, they have a performance requirement, which is H8P1, that basically says a class 1 building must be provided with continuous and step-free access. And it gives different avenues for that. It can be either from the pedestrian or from a glass tank garage or from a car parking space, and one level step-free entrance door to the dwelling, as required by A. But then you go at the deemed to satisfy provisions and you say, you look at the deemed to satisfy provision is basically say that they need to follow ABCB standard for livable housing design, which translates and gives effect to that performance requirement in more detail and numerical and considers different things. But it also says that clause 1.1 of the ABCB standard does not need to be complied if the following apply, which is a step-free access as an apartment garage or carport is not provided, and one of them or following exists, which is that the slope or the site is not suitable for a step-free access because of the slope or because it cannot provide or there's insufficient space. And so an example of what a binding determination might look at is why is the step-free access not provided and how does that apply? Is it because the design prevents the sufficient space for that step-free access, or is it because the site doesn't have enough space to provide a design that gives step-free access? A second question that a binding determination might tackle is the criteria in H2D2A, which is the step-free access beyond the garage, if that is it because it's not provided because of the design, or is it because it's not provided because of the site constraints? So that's another possible way that the binding determination can interpret what that means. The other thing that the binding determination might want to look at is, does the exemption in H8D2, so the deemed to satisfy provisions, given that they mention the garage and the step-free access, they don't mention the pedestrian entry at the allotment boundary, and they don't mention the step-free level to the entrance door. So does it mean that that exemption doesn't apply to those two criteria or performance requirements? Do they still need to be provided regardless of the design and site constraints? So that's the type of thing that the binding determination would tackle. The practice note would be guidance. They would give advice. This is our view. This is what we think. But a binding determination would interpret and determine what it is, how to interpret, and what it means. So that's the basic difference between a practice note and a binding determination. It needs to interpret within the constraints of the framework as to what it means or what it doesn't mean. So with that, if we move to the next question and the next poll, it's a very simple one, tricky as well. So can the state building surveyor issue a binding determination to prescribe a change to the deemed to satisfy provisions in H82? So the answers possible are yes, the binding determinations apply to technical standards, and that is a technical standard. Yes, the binding determinations can change standards when they are not clear. Or no, the binding determination cannot change a standard, only interpret it if it's not clear. So I can see that we've reached around 350 responses already. And this is an interesting one. So what I can see from the results so far is that 85% say no, the binding determination cannot change a standard, only interpret it if it's not clear. However, 11%, so around 43 people, say yes, the binding determinations apply to technical standards, and H82 is a technical standard. The correct answer is no. Binding determinations cannot change a standard, only interpret it. It may have the effect of changing practices of practitioners where they were interpreting the standard wrongly. But it doesn't change the standard. It just prescribes that a certain interpretation is valid and the other interpretations are not valid. So it doesn't change the standard. It interprets within the constraints of those standards. And that's the end of my presentation. Thank you, everyone. Back to you, Frances.
Thanks, Herman. Okay, so I'm going to talk for a few minutes about NCC guidance materials, and then hopefully we'll have a few minutes to take some questions at the end. So please do have a think about whether you've got any questions and post them in the Q&A on Teams. So NCC guidance materials, what are they? They are documents that have been prepared and issued by the Australian Building Codes Board. That is the body that oversees the National Construction Code, and it publishes the code and does a lot of work in revising and updating the code from time to time. So the guidance materials provide advice and guidance on the application of provisions of the NCC in various areas. They take various forms. There are handbooks, infographics, guidelines, guidance notes. There's really actually a wealth of information on the ARBV website, which is pretty useful. Next slide, please. So what are they used for? They vary quite a bit. So there are some guidances you'll see they're very content specific to specific parts or even clauses of the NCC. So for example, there is a guidance note on thermal bridging, there's guidance notes on guttering, downpipes and overflow, on condensation in buildings. Or it might be a more generalised sort of guidance where topics are grouped together and a handbook is created. So, for example, there is the Apartment Energy Efficiency Handbook. There is the Livable Housing Design Handbook that sort of gathers together all of the or some of the relevant materials that might relate to, Class 1A buildings, for example. And then there are other guidance documents that relate more to process rather than to content. So, for example, the process for putting together a performance solution under the code, the assessment methods that can be used by a building surveyor in assessing a performance solution. You may be aware that that is a sort of, there's a series of steps that need to be followed, and there are different methods of reaching satisfaction as to whether or not a performance solution will meet the relevant performance requirement in the NCC. And then another example is bushfire verification methods. So that's more to do with whether a design will meet the relevant bushfire attack level classification that has been imposed for that particular site. Next slide, please. An example is the guidance note issued late last year on thermal bridging. The way that document works is it gives a practical explanation of what it is. It sets out what the NCC provisions require. It then applies those provisions to, for example, roofs and ceilings, and then to external walls. It describes how it applies to, for example, sole occupancy units, how it applies to common areas in apartment buildings, and then how to fix thermal bridges is also dealt with. Next slide, please. This is an example of the thermal bridging guidance issued by the NCC. If you could just jump to the next slide, please. You can see it's reasonably detailed and it's reasonably technical, but it is sort of drafted in a pretty clear use of language so that it's quite readable. It provides different case studies. Next slide, please. And you can see it also includes some diagrams and some sort of practical detail. And it includes references to other resources on the ARBV website. Next slide, please. You can see that in NCC guidance materials are located on the ARBV website. There's a link there, but you can also just Google it and it'll take you there. The NCC guidance materials are similar to the practice notes in the sense that they are a guidance document that has been issued by a government authority, but it is similar to a practice note. It doesn't have the force of law. It's not something that you can point to and say, this is the law itself. It's merely, designed to assist you in understanding how the provisions might apply to any kind of given situation. So it's a useful tool, but it can be distinguished from other documents like guidelines, determinations, in the sense that it doesn't have that force of law. So that takes us to our last quiz question, where different reference materials such as a binding determination, NCC guidance, or VBA practice note appear inconsistent, which document should take priority? So I'll give you a minute to post an answer to that. You can just type your answer in because it's not multiple choice. Okay, well, we've got 300 and almost 400 responses now, and so the answer is that a binding determination would take priority because it has, it is, as the name says, it's binding, whereas NCC Guidance and VBA Practice Notes are not binding. And just as an additional note to that, I would say that in terms of ministerial guidelines, which I didn't put into the question, I think you can safely assume that there won't be overlap between ministerial guidelines and binding determinations, because guidelines can only be issued by the minister where there's a specific power under the Act. And so it's very unlikely that there would be a sort of an interaction or an inconsistency between the subject matter of a binding determination and a ministerial guideline. So that brings us to the end of our talk today, and we've got a couple of minutes if anybody wants to post questions in the Q&A section on Teams, please do so. Now, I might just jump in here. I did notice there was a question earlier on that I noticed, and that was about whether there are binding determinations in other jurisdictions in Australia. And Herman, I'll throw to you in a second, but I might just start by saying that I'm not aware of any other jurisdictions employing this approach. And it would be the question also asked, when will there be harmonisation of this? And certainly from my perspective, harmonisation of the building laws between the different jurisdictions is very desirable, and there's been lots of talk about that happening, but we are unfortunately a long way away from that yet. But Herman, you might know a bit more about this than me. Can I throw to you on that?
Yes, thanks, Frances. You're correct. There is no similar or equivalent tool or power in other jurisdictions with regards to, similar to the binding determination power and tool that is given to the state building surveyor. In fact, the function and the figure of the state building surveyor as a quasi-independent figure within the Victorian Building Authority, it's obviously not independent. We are part of the Victoria Building Authority, but that figure of the technical expertise with its own statutory legislative functions is somewhat different from the rest of jurisdictions as well. In terms of harmonization, well, I am obviously not in charge of that. That is a matter for all jurisdictions to consider, and there's obviously national processes that address that at a ministerial level. There is a very strong push for harmonization, whether a similar function to the state building surveyor or binding determinations is part of that. I am not privy to those conversations, so sure I can't provide an answer.
Another question that came up earlier was in relation to the question of when Part 5 of the building regulation applies. The question is, if a design only requires a planning permit for a heritage overlay, does the building surveyor assess against Part 5 siting of building regulations or against a res code for siting? You'd really have to look at that on a case-by-case basis. So what the building regulations requires, I think it's regulation 68 that says that Part 5 will not apply where a building permit is required, where a planning permit is required and where the planning scheme provisions regulate the same things as as Part 5 of the building regulations. So I would say the answer is probably that Part 5 does not apply in that scenario. Herman, were there any questions that you wanted to answer?
Yes, Francis, there was one about are binding determinations typically incorporated into future NCC editions? Those are separate documents and they are separate jurisdictions. So the brief answer is no, not automatically. However, if the State Building Surveyor in Victoria issues a binding determination on a particular NCC standard, and the rest of the jurisdictions and through the process of the ABC board or the building, the BCC or the plumbing PCC, they consider that that interpretation or that further strengthening in terms of clarity is warranted to be incorporated into the NCC, then that's obviously a viable approach, and it's available to jurisdictions and the ABCB to incorporate, but no, not automatically and not by definition. They are separate jurisdiction documents and therefore separate statuses.
Okay, well, I'm conscious of the fact that we've reached 1 p.m. So it might be best for us to leave it there, but thank you everyone for joining us today and for answering the questions. I hope you've found it useful, and thank you in particular to Herman for joining from the VBA. I think we all look forward with a lot of interest to see the binding determinations and how they work, and I think they'll be of great assistance. So thank you everyone.